Fun Asia Radio 104.9 FM, bringing the community together since 2002. मैं हूँ आपकी होस्ट मीठू और आपका और मेरा साथ रहेगा 12 बजे तक. Well, now is the time to give me a call back. I'm calling out to all the people who were trying to get connected with Pallavi. Well, this is the time to reach. This is your business matter with Pallavi Ahluwalia. And you can call us at 972-235-5555. So if you have any question related to employment or family-based immigration, family law, corporate law, or civil matters, now is the time to call us. 972-235-5555. That's the number in the studio. AhluwaliaLaw.com has all the information that you require to get in touch with them. To reach them, you can call their front desk manager at 972-361-0606. With that, do want to welcome Pallavi Ahluwalia on the airwaves of Fun Asia Radio 104.9 FM. A very, very good morning to you, Pallavi. How are you?
A wonderful morning to you, Meetu. Glad to have you back. Hope you had a great trip to India. We missed you here. Indu ably handled your part, but we did miss you while you were gone, and I'm glad to be hosted again with you.
I'm glad to be back too. It felt like a very short vacation. I know it was a long one. It felt very short one though.
All right. So I know we have a lot of callers that are already waiting for us, so
that's
I
right.
can start taking calls.
Let's do that, and let's take our first caller on the air. 972-235-5555 number in the studio. Going to our first caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question to Pallavi.
Hi there, Ms. Pallavi. Thank you for your time. So here's the situation. Employer has filed the I-140 that has already been approved, but said that they will not file the I-485, reason being prevailing wage is lower than what was filed in the form and the I-120. So what options does the employee have? And what are the risks?
Okay, so you're obviously a current category at this time.
That's correct.
So that's the reason you're being able to file the 485, and the employer says that. So the obligation on part of the employer, you have to understand, is to pay you the prevailing wage as soon as you have that green card. They have to show the ability to pay the wage going up until the green card, till you obtain it. But right after you have that green card approved, they have to pay you the promised wage as on the perm. So I mean, that's not something that I see that often, but all I can say is that is an employer's prerogative if they are saying that they cannot pay that wage and they don't want to file it for the sake of filing.
So the employee has the right to file the I-485 without the help of the employer. I know where it gets tricky is the employment verification. So that letter can be requested because it's generic from the HR department. However, it will only state the employee's current wage and that the employee is currently being employed.
That won't let it get approved. That won't let it get approved because there is a standard format to that letter, the one that you correctly call as a general letter. But it does promise the confirmation from the employer to pay the prevailing wage. That is a letter that completely states that this is a job offer that is contingent on you getting approved for your permanent residency and promises the prevailing wage that arose from that perm.
Okay, so even if the position's met, salary is not met, it won't work.
Correct. Then USCIS has a chance to come back and deny the 485.
Have you seen a lot of that being common, where they go ahead and deny it?
They will, they will deny it, for sure. Because they will match that wage. That has to match.
Okay.
Yeah, that has to match. Yeah, it cannot be.
So no options, I guess, nothing.
Yeah, even if we see like 20 cents off, we will come down and put our foot down and say that it has to be that exact amount. If it's more, that's fine, but it cannot be less than the amount that's stated on that perm and the prevailing wage.
Okay. The other situation is that, the employee goes ahead and files the I-485. If until 180 days they don't hear back, they can do the AC-21, change employers, and have a letter that actually matches that. Would that work?
Okay, so let's go past this. So what happens is that the AC-21, in terms of true portability, in you not having to do anything with it, as in refiling the perm or recapturing the priority date, works only if the I-140 has been approved, number one, which you have, and the 485 has been pending for 180 days for 6 months. Okay, after that is approved is when you can AC-21 port, which means you can go to another employer and say that you can give me whatever wage, but that employer, the next employer, for AC-21 purposes, if they stand in place of the employer one, have to give a letter that confirms the wage again. Yeah. So that wage would stand even with the other employer, but it would only come into place once your 485 has been pending for 6 months.
So that's a risk, right, that you're taking?
Correct. So first of all, you're filing for 6 months. Your employer first has to state that they're paying you the ability. They have the ability to pay. Then you're moving to another employer 6 months later. They have to say the same thing, right? So those are the requirements of AC-21. Well, another thing is if you have your I-140 approved and it's been approved for over 180 days, then you can move to another employer, and another employer can recapture that priority date for you by doing a perm and doing an I-140 and all of that.
Okay, sure. One last thing. The I-485, what is the processing time? Is it normal for it to be past 180 days?
Yeah, it takes about 4 to 6 months, sometimes 8 months. But, it just depends on what is going on in the back. We sometimes cannot fathom it because once in a while I'll be surprised when I get a case approved in 3 months or 2 months. So it just depends. It really does.
All right. Thank you so much for
all the best to you.
Call. All the very best to you. 972-235-5555. This is Your Business Matters with Pallavi Ahluwalia. If you have a question, now is the time to call us. Going to our next caller, and can I request all of you to please keep your question brief so that we can take more and more calls on it. I know your questions are valid, but let's give chance to everybody who are trying frantically here. All right, going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question, please.
Yes, I apply for my brother and sister. I'm U.S. citizen, and I apply my brother and sister in 2008. How much time still take for that F4 category?
Yeah, so right now for India, it's the dates that are getting their green cards are January 1st of 2001. So at least 8 to 9 years is what I'd say, because the visa bulletin doesn't move every month by a month. So you should give it more time than what it states on the visa bulletin. So right now, just looking at the visa bulletin, it seems about 7 years, but I would say 8 to 9 years at least.
Oh, okay. Thank you so much.
All the best.
Thank you for your call. Ahluwalialaw.com is the website to go and find out more about them. Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question, please. Phanisha Radio, you're live on the air. Go ahead and ask your question, please.
Hi, I'm planning to file green card for my mother. I'm a U.S. citizen, have been a citizen since 2010. She is already in U.S. on visitor visa. She's on.
How long has she been here?
She's been here 3 months, a little over 3 months.
Okay, got it. Okay, go ahead.
And so I wanted to file that application and 485 at the same time, or
yes,
we file one and then wait for the approval?
Right. So we're losing you in the middle, but I'm kind of just understanding what you may be asking me. So I'm going to respond generically. And if you ask me the question that do you have to file the I-130 and 485 concurrently, the answer is yes. So I'm just losing you in the middle. I think we have just a poor cell connection. But yes, you can file the I-130 and 485 concurrently.
Okay, I'm going to hang person on the radio.
Okay. All right. So the answer to your question is that yes, you can file. Your mom, if she's been here already for 3 months, she can file right now. She's filing concurrently, and I-130, 485 can be done. Along with that, there will be more associated forms. The biographic information form has to be enclosed. The birth certificates are the most important thing, and they have to be there. Otherwise, those are the cases in which there are these horrendous audits or the request for evidence, as they call them, and they get denied for some strange reason. USCIS will make some harsh decisions. So just be careful about the birth documents for both mom and you. All right. I think she's not here to just ask us more
we
questions.
disconnected so that she could hear on the radio. Going to our next caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question, please.
Hello, Pallavi, ma'am. Ma'am, my parents' visitor visa got denied 3 times. So, is there any chance they can get it if they apply it again, or they shouldn't try it again?
Yeah, so do you know what the reason for denial is, or the council doesn't give any opinion?
The first time it was not sponsored because we were in India. Our visa is mixed out, so we couldn't sponsor it. So they said it's not sponsored, so you cannot get the visa. Second time we were in USA and we sponsored it. Then they say earlier it was not sponsored and this time it is sponsored. So you conceal the facts. Third time they tried it through group visa and they again denied it. And they're not ready to look at any document or not listen to anything.
Okay, so the success of a visitor visa application depends on 3 things or 3 criteria that the government looks at. Number 1 is the reason for the visit, and it's okay to say that you're here to travel in the US and come here. Nothing less about family and more about travel and shopping. Those are the reasons. Number 2 is their financial strength in the home country, and they have property ownership or things there, and emotional ties back to the home country.
Ma'am, they are having all the documents, but they are not ready to listen to anything, or they didn't look at any document. Means
okay, so then it may be that the second time around that you're trying to conceal facts or something that they had an issue with, that may be a hold they may have against their names. Okay, basically, if they put anything towards immigration fraud or even the appearance of fraud, then it will be a difficult category to get approved on. Okay. So basically, if the government at the consulate stage has been able to spot that there was some irregularity, for whatever reason it may be, they will not approve the case again. So even if you were to try it again, so if you have an option to file a green card later on for them or anything like that, that may work okay, but not this. The visitor visa is very, very rudimentary in the analysis. Okay?
Okay, thank you, ma'am. Thank you so much.
All the best to you.
All right, thank you for your call. Going to our next caller, 972-235-5555. For all who are tuning in just now, this is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. And if you want to get in touch with Pallavi beyond the show, you must get in touch with the front desk manager at Pallavi's office, and the number is 972-361-0606. Going to our next caller, Fanisha Radio. You're live on the air. Go ahead and ask your question, please.
Hello?
Yes.
Go ahead, please.
Yes, hi, Pallavi. I had a question. My daughter is 21 and she's a firm resident. Is it easy to apply for her citizenship, or, what do we need? What paperwork do we need for her?
So, tell me the age of your daughter.
21. She's going to be 22 in 6 months.
Okay. Then the other question I have is, are you U.S. citizens already, or did you become a U.S. citizen before she was 18?
Yes, I'm already a U.S. citizen through marriage.
Okay. And did she acquire her green card through you?
No.
Okay. So another question is, did you...
No, green card, yes. I'm sorry. She did.
Okay, so another question is that did you become a citizen while she was under the age of 18?
No.
Okay, all right. So yes, she'll have to apply for her naturalization. What I was thinking is, if she had derived citizenship through you, which would just have apply for a certificate of naturalization as opposed to going through the process. At this time, at the age of 22 also, or 21, she will be filling out the N400 and the associated proof and all the questions that have to be correctly answered. And yes, she'll have to go through this process.
Through the process. And will the process be same as mine, or will it be a little easier? Because I had to provide a bunch of paperwork,
Yes, because you probably got your citizenship after 3 years of your permanent residency, right? So you could apply for 2.9-year mark because you were married to a U.S. citizen. And so in that case, you had to provide bona fides of your relationship with your husband. If she's been a permanent resident, which she would have been for 5 years, then she's eligible and she doesn't have to go through the bona bona fides of your relationship with your husband anymore.
Right, so she can do it and it will be easier. And would it need legal like help, or is it
I
easy
just love this. I just love this. Everybody asks the attorney whether you need them or not.
I know.
If you're comfortable, well, yes. If you're comfortable, of course, why not? Just make sure that she's aware of what she's doing, and if she can, then yeah, good luck. She can.
Okay, and can I be with her at her interview, or do I need a permission? Can I go with her?
And no, her interview is going to be related on civics and English and all of that. And
is that all? Yeah.
Yes, yeah. So after she's the age of 21, then they will not allow anybody else to go with her.
Oh, okay. And so the questions are going to be just related to the booklet that they give, the civics and English. That's all, right?
Correct.
Nothing
Correct.
personal or anything.
No, there will not be any reason to, because she's had her 4.9 years at least of permanent residency, and she's qualified on her own.
Right. And once we apply, how long does it take for the fingerprinting and then interview?
So the times vary. It takes about 6 to 8 weeks for the fingerprinting, and the interview is usually supposed to be set up only after the fingerprints have cleared, which should not be an issue for her. There should not be no criminal charges in the last 5 years. Right? Even driving tickets have to be reported, and you have to have original records of that. So you have to just go through all those requirements and then make sure that she's complete with that. That way her green card, her naturalization can get approved at the first shot.
Oh, that's great. And the driving, she did get a ticket, and she defended it, with the defense driving and all that.
Got it.
That shouldn't be an issue, right?
She still has to take the record from the municipality or the city office and show that the ticket was paid off. It has to be an original record.
All right.
Okay. And
Thank you for...
All right. All the best to you.
Thank you for your question. And if you want to get in touch with Pallavi, you might want to take an appointment and give them a call, 972-361-0606. Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question, please.
Yes, hi. Good morning. My question is, my mom had applied for my sister on December 2007. Sorry, the priority date is 2007.
Okay. Your mom had applied for... Is your sister married or unmarried?
Yeah, my sister is married, living in Canada, and my mom is here, and she was from India.
And your mom is a U.S. citizen, correct?
Yes.
Okay. All right. So right now, the people under the F3 category that are getting their green cards are filed on December 1st of 2004.
Oh, 2004. Okay, so it's a long wait.
Yeah, and it doesn't move every month, unfortunately. So
okay.
Yeah, so
thank you very much.
All the best.
Have a nice day. Bye-bye.
You too. Bye-bye.
Thank you for your call. 972-235-5555, number in the studio. All right. Once again, if you want to get in touch with Pallavi, 972-361-0606. And it is very important that you take the appointment first. Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question, please. Phanisha Radio. Yeah.
Hello?
Yes, go ahead.
Hi, I was wondering if you guys are still selling tickets for Boostown today.
We can cater to that question a little later because I just returned from vacation and I'll have to find out if the tickets are still available. But give me a call right after the legal segment, okay? Thank you so much. Phanisha Radio, you're live on the air. Go ahead and ask your question.
Hi, this is Kos again. Thanks for taking my call. I have a question, I'm planning to change my employer. I have an approved I-140 with my current employer. For sure, my current employer will withdraw my I-140 within 60 days. So I want to apply for an EAD to my wife. So can I apply EAD with my new employer's approved H4 visa for my wife?
Yeah, no, the requirement is that when they cross-check, the I-140 must be open at that point.
Okay,
so if the I-140 has been denied and they'll check it in their records, if it's been withdrawn or anything, then she will not get the benefit because that is a requirement.
So suppose if I apply the day itself, if I resign from my company, so will that take more than a month or 2 months?
Yeah, so they're supposed to take at least 3 months. Okay, and sometimes they're taking longer also to process the EAD. So, and that's the reason.
All right.
Okay. Thank you.
Thank you for your call. Going to our next caller, Phanisha Radio. You are live on the air. Go ahead and ask your question, please.
Hi, my question was, I'm on L1A visa and I got approved in 2013. Then I renewed it in 2014. I got approved for 1 year. And I deposited my tax returns in 2013, 14, and now I'm doing 15. So, when do I qualify for a green card? And can I apply for a green card when this expires in 2017?
Yeah, so you have to maintain your status while you're trying for the green card. The green card category for you would be EB1C, right? And EB1C, which is a multinational manager executive based immigrant petition, is an L1A but with increased review on the financials of the company and you know how successful it's been able to be. So if all of those look good for you, it's not just a matter of filing it, but how well you've done, and there's been, you know, the hiring of employees as per the business plan that was done in year 1 and year 2 has just moved on, then it's a good time to apply for a green card. If the company is still struggling, not doing well, then I would not expose it because that would end up in a strong audit and then a denial.
So it's better to just wait for another year or so and
the waiting of the year would only be if next year you're planning to hire more people, because basically were you done as a manager or an executive?
I'm doing it as an executive.
Okay. Okay, and has the enterprise been able to hire more people?
Yeah, actually, yes.
Okay, so if it is that you are running payroll and you're playing the role of an executive and you can prove it to the government, then go ahead and file now. That should not be an issue. The only thing is if the financials don't look good and you have not been able to grow is where my concern comes. But if you're growing and you show a healthy pattern of growth over the last 3 years, then you're good.
Okay, so if I renew it right now, my last question, I'm sorry. If I renew it right now, will I get approved for 2 years or another 2 years or 1 year?
L1As are allowed a total of 7 years. So you've had one renewal that would take you to 17, you said, right? And then if you are still kind of going ahead and the L1A category still exists for you, as in you can prove the case, then it would be 3 more years after that.
Okay. So I think I will just, all right. Thank you for your, thank you. I appreciate it. Have a great day.
Of course, you too.
Thank you so much. And we are almost towards the end. Probably we can squeeze in one last caller. Phanisha Radio, you're live on the air. Go ahead and quickly ask your question, please.
Hi. When my H4 to H1 is in process, change of status process, am I allowed to work with receipt number?
When your change of status is in process from H4 to H1 is what you're saying?
Correct.
Yes, no. You have to get it approved to be able to work. So if you're not qualified to work under the H4 EAD or you don't have any other options to work, then you will have to wait for an approval of the H1B to be able to work.
So I can't work with receipt number as I file from H4 to H1, right?
So there is something in the regulation in the section of 214, and that says that if you were previously on an H status, then you are allowed the portability, but just because the transfer or extensions in the country are taking over 8 months, I would not risk it. Either get it approved right off, as in get your premium processing done and get the case approved right off, so that you have the proof that you will be approved. So that is based on a very, very strong case where I would suggest anybody to move from an H4 to H1B. And that is at a deeper reading of the 214H, which is the regulation that governs H1Bs and H4s. However, because of the length of time, I would say no. So get it approved, then work.
All right.
Thank
you so much for your call, and thank you so much, Pallavi. Always appreciate your coming down to the studio and answering all the legal questions.
My absolute pleasure. I love to do this, and I'm so glad that I come here every Wednesday and talk to everybody in the community that has questions for me. And we always do end up with missing a few calls, and I hope that we can catch them next week for sure.
Absolutely. Thank you so much again.
Bye-bye.